Please the court receipt 24th of May 2023, state court case number 20A/113/2023, state against Senoe Ishmael Maswara. Your Worship, the matter was before you yesterday, was held over until today, and the appearances are as they were yesterday. As it is.
Thank you.
Mr. Court, please, I once more confirm my appearance on behalf of the first and fourth applicant in this bail application.
Your Worship, accused 3 has been represented by myself.
May it please the court, Your Worship, Masido Kwenani for accused number 6.
As it please the court, Your Worship, Gary Botha, attorneys, I confirm appearance of applicant number 5 in this matter.
Thank you. Yes,
Mr. Court, please, Your Worship. Your Worship, perhaps if I may address the court. Your Worship, I'm instructed to address and touch on basically 3 aspects and then go into what the court had required of us yesterday. Firstly, Your Worship, in his address, my learned colleague in his address went into detail in as far as the merits of this matter are concerned. And further went on to say that there's nothing that was advanced by the respondents. Your Worship, it is my instruction, this is a bail application, that the merits of this matter should not be determined by this court. And furthermore, that the affidavits by both the first and fourth applicant clearly reflect that as at the time that they drafted the affidavits, they were not in possession of the completed police docket, and therefore they did not know what case to meet. I will not belabor that point, Your Worship. Secondly, Your Worship, for this court to make a determination, it must take into account the entire evidence. It shouldn't confine itself merely to what the applicants have said under oath, but it must take it holistically, including the oral evidence that was led by the investigating officer. That would also include the cross-examination. And perhaps, Your Worship, this point goes to address the issue that was raised by my learned colleague for the state, in as far as he said, well, the state raised oral evidence, only affidavits were brought by the applicants. And I submit, Your Worship, that even with that said, it does not take away from the fact that this court is now more privileged. And we thank the respondent for leading evidence by the investigating officer, because had that not been done, the accused would not have even known what they are alleged on, or how they are even alleged to have been linked to this entire matter. Your Worship, a lot was said by my learned colleague in as far as the credibility of the investigating officer is concerned. But we respectfully submit that even at trial, it is not the credibility of the investigating officer that must be tested, but of the actual witnesses. I mean, if the investigating officer speaks, he speaks from a point of what he heard from other people. His credibility, strong or otherwise, shouldn't be affected. That is our respectful submission, Your Worship.
so in essence, you submit what he says is hearsay.
Indeed so, Your Worship.
And then, what is the rule?
Well, hearsay is admissible in bail proceedings. But hearsay, Your Worship, this court will accept, and this court will agree with me, that is not definitive evidence. It cannot be allocated the same value as proper evidence that is first-hand evidence. It's hearsay evidence. It is admissible in bail proceedings, but in no way will it then be said to be the gospel truth. Your Worship, in as far as the gambling and odd jobs are concerned, my colleague goes on to say that the applicants, particularly applicant number 1, number 4, are saying they're doing odd jobs and gambling. Your Worship, in no way was that rebutted. And I submit that that on its own says, this is what I do. There's nothing that says one must go into the detail, even the job description of what they do. They have placed it before this court. It is not rebutted. It stands to be accepted. Your Worship, I now tend to deal with the final aspect before moving to what the court has raised with us. And that would be the issues of the passports. Whether my learned colleague for the state went at length to say, well, they are grateful, which they rightfully should be, grateful for being given the passports, but at no point Was it explained that they were traveling to Lesotho or otherwise? Your Worship, I submit that if I hand to you my travel documents, I am in essence saying, here is even my travel history. Because otherwise, how else can one do it? Once you have a passport, you are guaranteed to have my travel history. And that is the submission, Your Worship. These were tendered by the applicants. The court must not lose sight of that. It is not as if they were withheld and later on, when the applicants discovered that the state had knowledge that they had passports, then the applicant changed their story. No, they were tendered to the respondent in this matter. And Your Worship, those would be our submissions.
But did the court had an insight as to information relating to their travelings?
Your Worship, the court did not have insight in as far as that is concerned. That we can concede, that the state would have insight because the documents were handed over to the police officers. But even with that said, Your Worship, one's travel history, unless it can be proven that it makes him a flight risk, has nothing to do with this. When one receives a passport, we take passports for one reason and one reason only, to travel, nothing else. No one takes a passport to keep it at home and do nothing with it.
So you agree that that was not disclosed to court? Because the argument that I had is that same was not disclosed to this court.
Indeed so, Your Worship. It was not disclosed by the first and fourth applicant, but we know that this court now knows. And how does this court know? There was oral evidence that was led to that extent. And the court cannot say, simply because it was not disclosed, it becomes a problem. The fact that the passport themselves were tendered should count in the applicant's favor. What is even more is that once now the court is aware of the travel nature of the applicants, the court can now safely say, come to a conclusion. And that is our submission, Your Worship. Your Worship, in as far as Section 64, particularly E, is concerned, it is my respectful submission that it is applicable in both Schedule 5 and 6 bail proceedings. I cannot really, I could not find anything to the contrary. And finally, Your Worship, the court raised an issue in as far as the children are concerned, and even went on to say to my learned colleague that, so what you are saying is in essence that none of the applicants are primary caregivers of the children. And my learned colleague said, that is so, that is the word that I was looking for. And Your Worship, I will respectfully refer this court to Chapter 3 of the Children's Act, and in particular Sections 18 to 29. And it is my submission that the parental rights and responsibilities of each parent is joined for each child. This court cannot say, without holding a proper inquiry in as far as the children are concerned, that that applicant number 1, for instance, is just supporting there but is not the primary caregiver. In fact, when one has a look at the Act says both parents are placed in equal footing. The primary residence of a child in no way takes away the primary caregiving role. And as far as applicant number 4 is concerned, it was mentioned that the children stay with their mother, and because they stay with their mother, applicant number 4 is not the primary caregiver. No. That is not the case, Your Worship. Our law and the Children's Act, I implore this court to once more read through those provisions. It is clear that primary residence has nothing to do with parental rights and responsibilities. The primary residence may be vested in one of the parents, but it does not take away the rights and responsibilities of the parent and of the child equally.
Well said, but the same, was it advanced to this court in the affidavits?
No, Your Worship. The applicant simply say, we have children and we are taking care of our children.
Fair enough. Thank you.
As the court pleases, Your Worship. Those will be our submission unless there's anything else from the court.
Nothing.
As the court pleases.
Mr. Makameli.
Thank you, Your Worship. Your Worship, I want to address this court on 2 issues. One of the is an issue that deals with rights and responsibilities of the caregiver of minor children. You'd recall, Your Worship, in our affidavit we indicated that the accused the second applicant in this matter has 7 children, and they are all staying with him. And I would recall we further said to this court that after, just before this escape, he then married the current wife that she's staying with. Now, it then means he is the person who's solely responsible for care of his children. All the rights and responsibilities are upon him insofar as these children are concerned. Because you'd recall also the investigating officer, when he testified, he said the 4 children are from different mothers. They do not belong to the current wife. So I'm saying that he is solely responsible for these children. Your Worship, this issue was also addressed in the matter of State versus Peterson, 2008 to SACR 355C, wherein the court said, inasmuch as a decision in regard to an accused bail application and subsequent appeal, should the bail be refused, will of necessity impact upon a child of the accused. It may not be lost sight that the child's best interests are, in terms of Section 28(2) of the Constitution, paramount. So that's basically what I'm saying. The interest of the minor, of the children of the applicant number 2 are of paramount in terms of the Constitution, which the court correctly raised in terms of Section 28 of the Constitution. On the issue of the affidavits, Your Worship, that from what my learned colleague raised, that does not suffice to be a evidence that has been adduced. It's my respectful submission, Your Worship, that yes, indeed, the accused submitted an affidavit to this court wherein he stated his personal circumstances. Even if, Your Worship, he was still going to testify before this court, the evidence that he was going to adduce was going to be basically surrounding his personal circumstances. Because what we said earlier on was that we're not going to deal with the merits. The merits are for the trial court. And Your Worship, it came out to light that the accused then made some pointing outs. Accused made, there's a purported confession insofar as this is concerned. Our take insofar as that is concerned, we are saying all those matters, because we do not even know the circumstances under which this was said, are matters for the trial court and will be dealt with in accordance accordingly at the trial court, Your Worship, as a court basis. Unless there's any other aspect that this court would like to hear me upon, that's basically my address.
If it was the intention of applicant number 2 to argue before this court that he is a primary caregiver as contemplated under the provisions of Section 28 of the Constitution, Section 9 of the Children's Act, why in your argument same was not brought to this court? Or rather, why was it not argued to this court that he is a primary caregiver as contemplated by the provisions of Section 28 as well as the Children's Court Act?
Well, Your Worship, unless the courts would want us to say specifically the wording as you have just alluded to now, but what we're saying is that in the affidavit it's explicit and very clear that all these children are staying with him. That's how we addressed it in the affidavit. Something that unless the court wanted it specifically to say that is the primary caregiver in terms of the Constitution and the Child's Act.
Yes, but staying with the child or children is different from being a primary caregiver, because anyone can stay with the children but not being a primary caregiver.
But I beg to differ with the court on that. With due respect, Your Worship, in this matter, I beg to differ with this court. Your Worship, he stays with his children. He's the only person that is working in the family who would ensure that all the needs of the minor children are taken care of, implying, in essence, that he's a primary caregiver of the minor children.
Yeah, but I cannot just infer.
That's what I'm saying.
You must be specific, yes.
Unless this court would have wanted us to address it in that fashion. But what I'm saying is, in essence, that's basically the idea of him being the primary caregiver of this minor child that he's staying with, Your Worship.
So do you agree that that issue was not specifically addressed to this court?
With the words that the court is currently using, Your Worship, yes, that would be the question. But we are saying, in essence, the issue was dealt with in terms of the affidavit.
Yes,
That's the court process.
yes, it was intended to be done so. It was not done, it was intended to be done so.
But as I'm saying, that's why I differ with the court. With due respect, Your Worship, I certainly differ with the court insofar as
Thank
that
you,
it's a question of interpretation on this issue.
Thank you.
Thank you.
Mr. Kwenani?
May it please the court, Your Worship. I think what we need to do in answering the issues that were raised sharply yesterday, we should look at the various methods of interpreting the text. And I think I should just remind the court that it would be ideal if, in interpreting the section that we referred to, section 60, subsection 4, if the court could actually interpret that contextually. The question that we asked was, do I think that section 60, subsection 4E applies to schedule 5 and schedule 6? And before we answer that, I would like to say to this honorable court that we should guard, or the court should guard, against the approach which yesterday I referred to as ticking the box approach, in which we're going to say this element is there, this one is not there, that one is there, and given this, I'm going to now deny bail. I would urge this honorable court that we consider very clearly what was said, and I know that I've read that judgment yesterday of State versus Diali. The caution that was actually given, if one should say that, by Judge Kubusha. When Judge Kubusha said, a court cannot find the refusal of bail is in the interest of justice merely because there is a risk or a possibility that one or more of the consequences mentioned in section 60, subsection 4 will result. The court must not grope in the dark and speculate. A finding must be made on the probabilities. Meaning it's not going to help us to say section 60, subsection 4E applies or does not apply. It should be looked at together with other factors that are mentioned under that particular section. And not only that, each one must be given weight. And whenever the court looks at the weight that needs to be given to a particular factor, it should not just isolate it. It should be, the court should actually attempt to look at all factors and make a ruling based on all those factors. It would be very, very loath to just answer the question that was posed yesterday by simply saying, yes, that particular factor mentioned in section 60, subsection 4E applies to both Schedule 5 and Schedule 6. Yes, it does apply, but we need to look at the holistic picture. Hence I said that the approach that needs to be adopted by this honorable court should be very, very contextual. Let me take this argument further. If we look at the question that was actually raised pertaining to primary caregiver, and I must say that I absolutely align myself with my learned colleague, Mr. Mururi, when he actually says that both parents actually need to be seen as contributing to the bringing and the rearing, in this case, of a child. And I want to take it further. In the case of accused number 6, if you are going to say, Your Worship, or if the court is going to say that the wife of accused number 6 is a primary caregiver, the court would equally have to consider the fact that the mother of the children of accused number 6 is not working, and the court would have to bear in mind that accused number 6 is a breadwinner. And in the context that was actually elucidated by my learned colleague, Mr. Mururi, it would beg a question: what do you do under those circumstances? So the court would do well to actually run away from a very simplistic notion of a binary type of thinking or of argument or of interpretation of saying this is a primary caregiver, this one is not a primary caregiver, as it was actually pushed by my learned colleague of the prosecution. In fact, my learned colleague has actually even taken this argument further and said in all these instances, these people, the children are staying with the accused, and there is somebody also that actually stays with children. We must absolutely run away from that. And I know that Mr. Mururu would be dying also to say that it is the concept of primary caregiver actually defined in the Children's Act. But I'll leave it there. I would absolutely leave it there and then deal with.
If I understand you, firstly, on these two aspects. First, Section 60, subsection 4E, you agree it's applicable in both Schedule 5 and Schedule 6?
Yes, absolutely.
Thank you. Then Section 28, the issue of children being the best person who interest must be taken care of. You also submit that the court should have inferred or must infer from your submissions.
No, I don't want the court to infer. In actual fact, in Exhibit D1, which is our affidavit, the affidavit of my client, he has absolutely written it that he's a breadwinner. And we would like this honorable court to look at it as it is. It says that Mr. Masukela is a breadwinner to his children. I don't want the court to actually infer anything.
Is there a distinction between a breadwinner and a primary caregiver as contemplated in the legislation?
I think I like the question that the court is actually asking now, because it says to me the court seems to be now taking the position that I'm at pains to explain. That says that rather than elevating one parent and saying that this is a primary caregiver, you should look at the role that is being played by both parents. I think it seems like the court is now taking that position, unless I'm actually giving I'm interpreting the court wrongly.
No, not necessarily, but I'm saying, is there a distinction between a breadwinner and a primary caregiver as per legislation?
There could be, but remember, Your Worship, the court would remember that I'm saying the Act seems to be saying that you should look at both as playing a role. As a matter of fact, I do not believe that in the latest, in the amended Act, the concept of primary caregiver is there. I don't believe it is there. It is not there. But basically, it says that accord the parents the role that they play. That would be my submission, and I'm going to leave it there. Okay. And there was another issue that, the other issue that was actually raised yesterday was an issue pertaining to how one gets the evidence. Look, it doesn't matter whether one is going to actually have viva voce evidence, or whether one is going to actually have evidence being adduced through the affidavits. My learned colleague is correct when he says that ordinarily you would not give them the same weight, but there's no way when you look at the aspect pertaining to interpretation, where it says that if the evidence is on the table and it is being supplemented by viva voce evidence, and then there's cross examination, that it necessarily means that this evidence that has actually been gathered through the affidavit would be a weaker evidence. No, the approach still is, as I said, as we are at pains to say, the approach should still be take the whole context and then make judgment based on that. Of course, we understand why my learned colleague would actually tease out the issue that they had left Kernel here, giving viva voce evidence. Obviously, he wants to create a scenario where it can be said that we led a better evidence. But that should not be the approach. The approach should be very contextualized. We should look at the rest of the context. We should look at the concessions that he had made. We should look at any other tested evidence and everything around what was happening here. And this takes me to the last aspect pertaining to...
Before you make a concession, that issue of a weight, it's a point that must be looked into differently when checking viva voce evidence and evidence through affidavit.
I want the court to bear in mind.
No, I'm just asking, are you making a concession? Because I've heard you saying your learned friend might be correct in relation to a question of weight. That is
I'm
what...
trying to answer that.
Yes.
If the court can be patient, I'm quite aware that I can be a bit long-winded, and I love the court to be patient with me, because as I grow and have a less scope, I tend to be long-winded. What I'm saying is this, to this honorable court. I'm saying, look at, let's say, look at, where did you get that viva voce evidence? Most likely in the cases that have been referred to was probably in the context of a trial as compared to in a context of a bail, for instance.
Yeah, Mr. Kwanani, don't extend it too far. Issue of weight.
I'm saying...
Approach should be differently or not?
No, I'm saying, Your Worship, if Your Worship would hear me, I'm saying I agree that it can be given different, it gets to be given different weights. But most likely, the very interpretation was within a context of a trial, not even in a context of a bail. And I leave it there, Your Worship. I see that Your Worship is actually pondering.
Yes,
you also found that.
Yeah, you are confusing me now. When you talk of trial weights in relation to trial, whilst we are busy with the bail.
Your Worship, I'm saying, and I want the court to follow me here, follow my argument. I'm saying I agree with regard to what my learned colleague said pertaining to
weight to be attached.
Weight to be attached to viva voce evidence. But I'm saying, and I want the court to follow me here, I'm saying, but that's not the end of the story. You can't say, oh, that's the case, full stop, everybody can now go home happy. No, we're not saying that. We're saying, well, I'm saying, yes, up to that level, yes. Viva voce evidence would be granted more weight than evidence that was gathered through the affidavit. But I'm saying that is not the end of the story. Put that weight, but still look at the other aspects pertaining to the case. And that's my argument. Okay. I believe I must be done with the issues that the court wanted to wanted us to raise. Except safe to say that let us not approach it as a ticking box exercise. Let us look at things holistically. Court, please.
And have you done justice in reaction to the address by the public prosecutor on other issues?
Look, the issue that he was at pains to actually outline, I sincerely believe that my learned colleague, Mr. Mururi, has dealt with that particular matter. The matter pertaining to credibility, which indeed, quite correctly, gets to be an aspect of a trial court. The purpose of bringing witnesses to a bail hearing is to enable the court to have enough, at least enough insight to adjudicate on two matters, and two matters only. Is this person a flight risk? Is this person likely to commit other offenses? Quite frankly, that is the scope and the purpose of a bail hearing. Now, for us to sit here and start saying that, but that one was very credible, that one was not credible, and so on and so forth, I think it's almost like it will lead us to a very undesirable situation where we would find ourselves looking for the needle, as the idiom should be saying, a needle in a haystack. And I don't think that that's the purpose of bail. The purpose of bail is to find out, is this gentleman likely, or this lady likely to come back to court? Is this person not going to commit further offenses? And when I say further offenses, that would also include having to meddle with the witnesses and having to see to it that the truth does not come to court as it should, That's people, pretty much that's our position with regard to that.
So according to you, issue of credibility is only limited for trial purpose or during trial, not during bail application, when the court is dealing with the witness.
I think it pretty much plays a lesser role, because in a number of aspects, for instance, a witness would be saying, yes, indeed, I have checked, the address is correct, and so on and so forth. For me, it plays a major, not such an important role, such as that it would play in a trial court. That's my submission.
Thank you. Mr. Gary Botta.
Thank you, Worship. As it pleases the court, Your Worship. Your Worship, I will concede that Section 64E is applicable in Schedule 5 and Schedule 6 offences, Your Worship. Your Worship, the question regarding primary caregiver, where does the child permanently resides, Your Worship? My submission is applicant number 5 is the primary caregiver. She put the circumstances in front of court. She has 2 children from 2 different men, Your Worship. They are only financially paying towards the maintenance of the children, Your Worship. But the end of the day is the children is staying with applicant number 5, Your Worship, at the premises where she's staying with the father and the mother. Due to the fact that she was suspended and dismissed, she had to move back to her father and mother's place, Your Worship. It is my mission that applicant number 5 is the primary caregiver of both the children, Your Worship. And I want to refer the state to State versus Peterson. It's a 2008 decision, volume 2, SACR, page 335, C. The interests of the minor children were dealt with in State versus Peterson, and it was held in paragraph 63 at 372 to 373 that when in an application for bail, the personal circumstances relied on by the accused includes the constitutionality protected interest of the minor child. This court must, in terms of Section 28 of the Constitution of the Republic of South Africa 1996, take recognitions of the child's right to family care and to parental care or to appropriate alternative care. Appropriate care when removed from a family environment, Your Worship. It is my submission, Your Worship, that applicant number 5 is the primary caregiver of the children. Personal circumstances is front of court. The children is staying with her, Your Worship. That is the, and the court has to make a decision, Your Worship, on that.
Yeah, Mr. Bota, you see, it is hard, if not possible, for this court to understand why these nice submissions are only made now after the court has invited all the parties to address on Section 28 of the Constitution. And then why this from onset was not portrayed in the affidavits during the arguments. It was never said, this court was never told. It only comes after the court invites. That is what it is difficult to understand for this court.
Your Worship, but not in all instances. In most instances, a child born with a mother, and usually a child stays with a mother unless there is circumstances where parties have to intervene by social workers, Your Worship. But it is my submission that in most instances, children are bound to stay with the mother, Your Worship. And it is my submission that I want to say it was not necessary to put it in the affidavit, Your Worship, but for the fact that in the affidavit of applicant number 5, she informed the court that the children is staying with me and I'm taking care of the children. The fathers is just contributing, Your Worship.
Thank you.
Another aspect, Your Worship, that my learned colleague has addressed the court yesterday regarding the affidavit of applicant number 5, that my colleague addressed that applicant number 5 wants to go back to work, Your Worship. According to our understanding, the affidavit or applicant number 5 that was read into court is applicant number 5 says she wants to be released to go and look for work, to look after the children. That is how I understand, Your Worship. Not to go back to G4S. And I need clarity on that aspect. Unless my learned colleague is in possession of another affidavit.
Are you done?
That is my argument, Your Worship. Thank you.
Thank you. Yes, Mr. Matoko, what must happen now?
Worship, we took the opportunity to look at the suitable date for the court's judgment, and we are all agreed that the date of the 29th of May, which is Monday, is suitable to all the parties. I'm not sure about the court, but should it be suitable to all the court as well, Your Worship. I have made my colleagues aware that I had an earlier commitment. I have a visual departmental hearing starting at 10, but which is likely not to proceed as pre-done, and I've therefore requested that perhaps, if it's suitable to the court, that we start at 12 o'clock, if it's suitable to the court.
Thank you, Mr. Murul.
Mr. Court pleases, Your Worship, if it's so pleasing to the court, then we will avail ourselves at noon on Monday. Mr. Court pleases.
That is in order, Your Worship. It has so been arranged.
Worship, I'm aware that I have a trial on the 29th, but if it's going to be at 12, I think I'll have to do a bit of buttering and negotiating with some of your learned colleagues to see whether would they enable us to be here on that particular day. But please.
Thank you.
As a President Court, I confirm 29 May 2023, 12 o'clock for judgment, Your Worship.
Thank you. You may rise up. Case is remanded until the 29th day of May 2023. Same court, court number 20A, for a judgment on bail application. All of you, you will remain in custody until then. Thank you.
As a President Court,
As President Court, Your Worship, I'm not aware if there's any other matters that the court still have to deal with, but I request that we adjourn until that is clear.
Thank you. Yes, court adjourns.
No one has